Good evening and welcome to the show. The High Court has temporarily suspended the implementation of 8 clauses of the controversial Security Laws Act, pending the hearing and determination of a case by court. In his ruling, Justice George Odunga said some of the clauses touch on fundamental issues in the Bill of Rights. Court leadership led by Raila Odinga and Wetangula welcomed the ruling, saying the court has protected the rights of the people of Kenya.
The High Court has suspended some sections of the controversial new security law, which was enacted 2 weeks ago despite fierce opposition. Judge George Odunga referred the case to Chief Justice William Otunga, who is expected to form a bench that will further deliberate on the case petitioned by Coalition for Reforms and Democracy.
Gangs of criminals.
The court blocked 8 measures until a legal challenge mounted by the opposition and rights groups is heard and determined.
This provision is likely to take the country back to the pre-2010 constitution dark days by enacting unto themselves the current constitution by way of a referendum. No doubt Kenyans intended to have a break from the past. It's therefore necessary that this part be investigated by the court.
The suspended measures include allowing security agents to intercept communications for purposes of deterring, detecting and disrupting terrorism, allowing security agents to seize any equipment that can be used to commit a crime, banning the publication or broadcasting of insulting, threatening or inciting material, images of dead or injured people likely to cause fear, and information that undermines security operations, including on social media. Also suspended is the clause that limits number of refugees and asylum seekers to 150,000 and those applying for refugee status to be restricted in camps.
My Lord, if you ask us to come back tomorrow to hear the petition, we would be ready to hear the petition. We don't have the luxury of time. And it looks like the National Assembly is more meticulous and efficient than the Office of the Attorney General. They were able to pass this law within 10 days. And they're requiring 30 days to respond to it.
At least you have upheld some portions of our Bill of Rights, that the media can continue to be free, be able to say what it wants to say.
The government has, however, applied for a 30-day stay of the conservatory orders directed by Justice Odunga, while Kenya National Commission on Human Rights and Kituo cha Sheria, who are interested parties in the case, objecting to partial issuance of the orders. After the ruling, the fully packed court went into song and dance, with court leadership expressing satisfaction with the court's directive.
The judge has also raised very serious concern and very strong opinions on the flawed manner and the chaotic situation under which the legislative process was undertaken in the National Assembly on the 18th.
What happened in the National Assembly on the 18th of this month, or last month, was not legislation. It could have been a scene in a movie somewhere. The Speaker was one of the actors, one of the poor actors, and a very poor actor at that.
The Chief Justice is expected to name a bench that will deliberate on the matter next week. A first-round victory for Coalition for Reforms and Democracy CORD, but whether their jubilation is long-lived or short-lived squarely lies with the bench that will be constituted by the Chief Justice. Aaron Ochieng, KTN, Nairobi.